we have Josh Blackley. He is an assistant professor at College of Law. He is the founder of SlowStances.org, which is essentially a fancy people don't hear about sports, but you take the facts and you see how judges are going to decide whether you're concerned, whether you dissent. So I really check it out. I also recommend you check out his work. Works online at the Institute. Speaking of DACA, one moment said we were a little late. We were coming to downtown court. So whenever you guys see, we'll go right ahead and go over today. But these really constitutional crimes against adult social and just some restrictions. We're very excited that we turns out I'm nominated for 2 Freddie Awards for the symposium, which is most creative and the most improved chapter. So we are competing against about 7 other chapters of those awards, but we're really happy. We got those awards last year, and we're excited to hope we got nominated for those awards, so hopefully we'll actually win. And we're really excited to go. It's going to be me and Bianca and one more person who will attend the symposium. And I'm really excited to.
Thank you. Thank you so much. It's a pleasure to be here. Professor Gomez will be here when he gets here, and we will happy to hear his comments at that time. The topic today is DACA. And I have a bit of a hard position with this topic because I like the policy of DACA. I think it's a good policy. And in particular, I wish that Congress would do something about the Dreamers and pass a permanent bill to address that issue. But my views on the policy are not the same as my views on the law. And I have very strong doubts that whether DACA is a legal policy. And I also think that President Trump was within his authority to rescind DACA. So it's in a weird spot. I like the policy, but I'm not sure if it's legal. My talk today will discuss the current Supreme Court decision, which was argued in November. And that decision concerns DACA. And I want to address 2 questions. First, was DACA itself legal? And second, was President Trump authorized to wind down the policy? Okay? So we have to do some history first. And let's go back to 2012. Many of you were probably not even in college yet. In 2012, Congress was considering a bill called the DREAM Act. The DREAM Act would have given a pathway to citizenship for the Dreamers. These were people who generally came to the country as minors, were not here lawfully. They played by the rules, they didn't get in trouble, they graduated from school, they're generally upright people. The DREAM Act would have given these people a pathway to permanent status, that is, citizenship. The DREAM Act actually passed in the House, but was voted down in the Senate, and did not receive enough votes. After the DREAM Act failed in Congress, President Obama announced that he would take an executive action to give relief to the Dreamers. And he announced a policy called DACA, Deferred Action for Childhood Arrivals, DACA. Now, DACA was not amnesty. DACA did not give citizenship to the Dreamers. Instead, it gave them something else, what's known as lawful presence. Okay, what is lawful presence? Lawful presence is a legal concept that means you're here, you don't have a permanent status, but we're not going to prioritize your removal. That is, if we have a list of people that we want to remove, we're going to put you at the bottom of that list. And while you're here, you have this lawful presence, you can work. You can get working papers, right? You can go to school, you can do a host of various things. You maybe can get a driver's license, right? You do different things because you have this lawful presence. Okay. That was in 2012. There were a few legal challenges to DACA in 2012, but for the most part, people liked it. People thought it was a popular policy, and there wasn't really any opposition. Now, at the time, I had my doubts about whether it was legal, but no one really focused on it. Fast forward to 2014. Congress was considering a second piece of legislation known as the Comprehensive Immigration Reform Bill, the Gang of Eight bill. This was Marco Rubio's last stand, so to speak. Remember that. This bill would have given a pathway to citizenship for millions of Americans who've been here for years without any sort of legal status. That bill passed the Senate, but it failed in the House. The House never brought it up for a vote. And the Speaker at the time, John Boehner, wanted to protect his members from taking an unpopular vote, so it never got up for a vote. After the immigration bill failed in Congress, President Obama announced once again, I will take an executive action. And that executive action was known as DAPA, D-A-P-A, Deferred Action for Parents of Americans and Lawful Permanent Residents. It's a mouthful. You have DACA in 2012 and DAPA in 2014. Okay? DAPA was different. It would have granted deferred action and lawful presence to the parents of U.S. citizens, right? So DACA was the dreamers themselves, the kids. DAPA was granting lawful presence to the parents of children who are citizens. Generally, children who are born here, they're citizens by virtue of the 14th Amendment. The parents are not. And generally, kids can't petition for their parents for a green card when the kid turns 21. So this would have given this lawful presence status to these adults who had children. They had to have no obvious criminal background, and they had to, pay some fees and such, but they were generally given this status. That's how the policy was supposed to work. This policy would never go into effect. The Texas Attorney General and some other conservative states challenged DAPA. They filed suit in federal district court in Brownsville, Texas. A well-chosen forum for them. By the way, if you learn in Civ Pro forum shopping's bad, no, it's not. Wait till you're a lawyer. You want to forum shop, right? If you are representing the plaintiff, you want to be in state court, especially in Florida. If you are the defendant, you want to be in federal court. So don't believe for a second forum shopping's bad. Everyone should forum shop. That's how lawyers work. Anyway, so they filed a suit in Brownsville, and a federal judge in Brownsville, Texas, declared DAPA unlawful and prevented it from going into effect. And the Fifth Circuit, in a couple opinions, affirmed and also ruled that DAPA was unlawful, that the president did not have the power to enact this policy. The case was then appealed to the Supreme Court, and the Supreme Court accepted review. At the time the Supreme Court accepted review, there were 9 justices. But by the time arguments were heard, there were only 8. Justice Scalia had died in February of 2016 before the case was argued. Died February 13th. Valentine's Day is always very sad for me for that reason. My grandpa died the same day, so it's a really, really sad day. February 13th, just X off the calendar. Both Scalia and grandpa. But the court was shorthanded, and the final decision was tied 4-4. When the Supreme Court splits a case 4-4, there is no decision, right? There's no actual merit decision. All you have is a judgment that says we affirm the lower court. We don't know why they affirmed the Fifth Circuit, but they affirmed it. Okay? That brings us to 2016. At that point, I expected Hillary Clinton to win the election and thought that the policy would simply continue as it was going before, and Merrick Garland or someone else would cast a 5th vote to uphold DAPA. That's what I thought would happen. I was wrong. So was everyone else, right? Trump won, and Neil Gorsuch replaced Scalia. But then something funny happened. Trump announced he was going to wind down DAPA, but he would leave DACA in place. He said, I have a special place in my heart for the dreamers. Okay. But then Texas comes back in, my home state, and Texas said, Trump, unless you rescind DACA, I'm going to sue you. I'm going to sue you unless you wind down DACA. And then the Trump administration had this turmoil because they didn't want to, but they also didn't want to get sued by Texas. So they announced that they were going to wind down and suspend DACA. That then triggered litigation by all the blue states, California and Maryland and all these other places, right? And they sued the Trump administration saying that the decision to rescind DACA was illegal. And that's the current case before the Supreme Court, okay? Several federal district court judges ruled that the president can rescind DACA, but the reason given by his administration are not adequate. In other words, you can do it, but you didn't give enough good reasons. Okay. What was the reason given by the Trump administration? The reason given was that DACA was illegal. Now, no court had actually held DACA was illegal. The Fifth Circuit held that a related policy, DAPA, was unlawful. but no court held DACA was illegal. But they drew an analogy. They said, we think DAPA and DACA are substantially similar, and if one's illegal, so is the other. Now, the various, hey, come on in. Hey, please have a seat. I'm just getting started. So the various courts ruled that DAPA could be rescinded, but because the justification given was inadequate, President Trump hasn't met the sufficient requirements to do so. All right, now we get to the Supreme Court part, perfect timing. So the Supreme Court really has a couple issues to consider. First, was the decision to rescind DACA supported? In other words, were the reasons given correct? Is a policy illegal? But even if they don't want to go down that road, the court can simply say, we don't have to agree with Trump, but are the justifications given to be reasonable? Okay. There's a second issue that has sort of floated in the background, but it's still lingering. Does President Trump have what you might call an unconstitutional animus towards Hispanics? And does that animus taint any effort to rescind DACA? In other words, would the rescission itself violate equal protection of the law? At least one judge said that was the case. I don't think the Supreme Court's going down that route. It's a little bit too attenuated. So I'll focus mostly on the statutory argument, right? Were the reasons given by the president correct, or at least reasonable, that there was a good likelihood the court would find DACA unlawful? So here's the basic legal argument. And this, by the way, is this argument is based on an amicus brief I filed on behalf of the Cato Institute in the Supreme Court. And I filed this brief, I think in August or September, so some months ago. The first issue we have to think about, right, is power. Where does where does the president get his power from? The president gets his power from two sources, right? Okay. Constitution and statutes. That's it, right? There are some powers written in the Constitution, and there's some powers written in a statute. That's it. In this case, there's no real argument that the president has what you might call an Article 2 power to enact DACA. That's just not an argument present. Article 2 concerns foreign affairs. I think you could actually make an argument you can deny people from entering, but once these people are in the United States, I think it's a matter of Congress. So the sole question then is, has Congress delegated the power to enact DACA to the administration, right? So where do we look to see about delegation? We say, well, what statutes are enacted? We have a lot of immigration laws. More pages in the Immigration Act than I can even count. Thousands and thousands of pages. And Congress makes a lot of decisions that are fairly specific. You know, how much of a fee you have to pay, how many years you have to wait, you know, maybe how many visas are available. There's some places where Congress speaks with specificity. And there are other places where they don't, where they kind of just make these general pronouncements and they go tell the executive branch, you guys figure it out, right? You take care of it. What we're dealing with here is something called deferred action, right? The idea that we're going to deprioritize removal and the related concept of lawful presence. There is no statute in which Congress gives the president or the attorney general the power to give deferred action. This is a sort of executive practice that's sort of grown outside the law, so to speak. There's no statute defining it, but the Supreme Court has recognized that this practice exists, and I don't take exception with that. I think it exists in terms of executive practice. Okay. So then the question is, does this sort of unwritten executive practice support a policy of the scale of DACA? Okay, and this is where I think DACA goes too far. As a general matter, when Congress says something explicitly in a statute, I think you have to be more deferential to the executive. But when the executive is acting based on these sort of implied powers, I think you have to be a little bit more precise. The only statutes that exist give general authority to the secretary to set priorities, right? To set priorities. I think you can't read these statutes by setting priorities broadly enough to justify DACA. Right? If Congress can give the president such broad powers in these sort of vague pronouncements, we have an issue with what's called the Non Delegation Doctrine, which you may have heard of in law school, in common law at least. And the Non Delegation Doctrine is a limit. It says Congress cannot give legislative powers to the executive, right? They must give what are called intelligible principles to the executive, right? They must give some guidance of how the law should be executed. If Congress can pass a statute that says the secretary can set priorities, and that's it, and that allows them to create this massive program for up to 1 million aliens to grant them lawful presence and work authorization, that statute has no intelligible principles. If merely saying set priorities is enough, that statute's unconstitutional, right? So I think the better argument is we read the statute narrowly. Congress, the court says, does not hide elephants in mouse holes, right? If Congress wants to give such a big authority, they must say so expressly. They can't do it through winks and nods. So I think the statutes that exist in the INA don't go far enough to give lawful presence, give deferred action to up to 1 million plus aliens. But there's another issue, the work authorization. There's a regulation which says those people who get lawful presence can get work authorization, and I don't quibble with that statute. That regulation's been on the books since the 1980s. But let me tell you something. When that regulation was first being proposed, a member of the executive branch went to Congress, and they asked him, how many people do you think would be eligible for this work authorization? What did he say? The number is so small that's not even worth keeping track of. Before DACA, thousands of people got this. Thousands, a very small number. Now it could be up to 1 million. I don't think Congress, when they enacted this law, had in mind such a broad way to bypass the normal channels of work authorization. Generally, for an immigrant to get working papers, it's hard. They got to hire a very smart lawyer, right? It's not easy. And DACA sidesteps a lot of that. So I think that this reading of the regulation goes far beyond what Congress had allowed. Let me make one final point, then I'll turn over to my friend, Professor Gomez. When we're talking about executive practice, we have to look at how have past presidents used this authority. A common defense of DACA is presidents going back to Eisenhower have used deferred action. True, but Congress enacted a lot of very important immigration laws in the early 1990s in a fairly short span. And those laws repealed many of the statutes that Eisenhower and others relied on. So I don't think they're relevant. Those statutes are out the window. Really, our only guiding point is the Clinton administration and the W administration, based on the last 15 or 20 years. And historically, historically deferred action was used as a bridge. That is, someone was in a position where they did not have status, and there was some status waiting for them at the end of the rainbow, right? There's something waiting for them that would happen. I'll give you an easy example, right? Let's say you were a student at Tulane University in New Orleans in 2005. Hurricane Katrina slams into the Gulf Coast. Your university shuts down, right? If you were a foreign student with a student visa and your school shuts down, guess what? You're out of status, right? You're not taking enough classes. So the Bush administration in 2005, 2006 said to students, as long as you enroll in another university by the next semester, we'll give you deferred action for 6 months, whatever happens to a year. We don't want you to have to be removed for being here without status. That was transitional, right? They knew there was something waiting from the end of the rainbow, right? That's not the case for DACA. With the DACA recipients, there's no status waiting for them. Now, maybe if they get married or have a petition from a relative, there might be some ancillary grounds in which they can have an adjustment of status. But by the very nature of merely being here for those years you're in DACA, there's nothing for you on the other end. So DACA was not consistent with past executive practices. It wasn't a transitional, temporary measure. It was really meant to be quasi-permanent until legislation was passed. I think if you had asked Obama, he would have said, yeah, let's just have this temporary thing and Congress will get their act together, and in 2016 we'll get a vote. And that didn't happen. We got Trump instead, right? But I think you have these sorts of policies that are very well-meaning, help a lot of people, but are not consistent with the law. Now, let me shift from law to policy for a minute. I think the court will likely hold that the president can wind down the policy. I don't think they'll touch whether itself is legal. They'll just say the president can end it. At that point, by June or July, President Trump will be in a tough spot because he'll have about 1 million dreamers whose status will be expiring in the next couple of years. I don't know what happens in Congress. That's going to be a mess, and I think it's going to be a disaster for the Republicans. It's not going to be pleasant to deal with. You've had these people on the status now for almost a decade, and they're in schools. Now they have law licenses in some states. They're doing all these wonderful things. It's going to be hard to simply put them back into removal status. So I don't know what happens. My focus is limited to the legal arguments. Again, I like DACA as a policy matter, but I don't think that the authorization given so far is consistent with the INA. I'll pause here, and I'll go sit down for a minute and turn over to Professor Gomez, and welcome to have some questions from you all later. Thank you all so much. Whatever you want. Yeah, I'll go sit down. Okay, yeah, let's do that. Let me come over here, pull a chair. Interior design in law school.
Yes. The endless worry is always, of course, did someone erase the board ahead of you, and did someone leave and erase her for you? So, thank you.
Good to see you. Thank you. And I think you were in court today?
Yes.
Well,
this is, and it's always an interesting thing because I agree with you that I'm torn in a certain way, and the hearing here comes in an odd situation, and I always think of sort of there's the law in the abstract, and then there's the law in implementation, and I'm one of those people who is very much afraid of all kinds of government, and including if anybody knows me, they know that I'm skeptical of things like homeowners associations because they are the most dangerous form of government.
I think I agree with that.
Including then you have private security companies and such, and it becomes a problem because one of the things that happens in the implementation is that you lose sight of what the bigger goal was. And one of the biggest problems that we have in immigration, and I agree that in 1990s, and there were several reforms. There was 1990, IMAC 90, which was supposed to sort of deal with some of the leftover issues from the 1986 reform under President Reagan, and the IRCA, which is Immigration Reform and Control Act, which has not worked out in the way that everybody thought it would work out. But the thing is, though, that see, in law, one of the biggest mistakes people make is that they think that it's a cure-all. You see what I'm saying? You all have a grandmother or grandfather or an aunt or someone like this who has a recipe for the thing that will cure every illness you have. And people don't understand that it's dangerous to think that any one piece of legislation will resolve everything. As a matter of fact, one of the things that happens is that different pieces of legislation over time tend to cause all sorts of problems, but then, of course, because of the dysfunction in the legislative process and the dysfunction in our overall society, that we can't be practical. As I always tell clients, tell me what your practical goal is, and then we'll discuss the practical goal, and then I'll give you a few minutes to vent as much as you want, but this is not the kind of case that goes to the Supreme Court. This is the kind of case where we resolve at an office in a window, and we hopefully will have it resolved in an easy way. But people don't have, lay people don't have a complete sense of what's happening. One of my favorite issues is if you think of INA 242, which is there's the courts, the federal courts don't have jurisdiction to review discretionary forms of relief. So it's usually when you see someone approaching litigation in federal court to challenge action, or if you're taking something up on appeal to a circuit court from an agency, you always make sure that you've exhausted all your legal arguments and that you've also raised your constitutional arguments, because if not, you have a problem in district court or in circuit court. And one of the things that happens is that you also have, in addition to the dysfunction in the world of legislation, because there have been various attempts. There was the McCain-Kennedy Act or legislation that was proposed in 2007, and again, one of my favorite comments on legislation is when no one is happy about it, that means there's practical in some way, because it's sort of like a settlement. Okay, you get something, we get something, let's move forward and see if we can do something about it. But then you have people, and one of the problems with resolving, for example, the DACA situation has been that one side wants sort of too much, and then the other side wants to create as many obstacles as possible, including absurd things like, for example, qualifying the parents of the Dreamers as smugglers because they allowed the child to remain here.
Oh, I haven't seen that. Is that going on now?
No, that's happened over time in several of the proposals. Every year, you know how they sort of submit one proposal or another, and then people try to sort of poison the main legislation so that no one in their right mind would vote for it.
The poison pill.
Yes, and so what happens is that, and it's very frustrating, because the thing is, though, that you have now approximately 700,000 people on DACA actively. That does not include the many others who, since it was sort of paralyzed, in other words, the door was closed to new applications in the fall of 2017, that you have a bunch of other people who need this remedy, who would be otherwise eligible for it, but it's not there. So the number is unclear, because one of the problems we had, and FIU was a big participant in helping people to get DACA, that one of the things that happened was that we went all over the place. We tried to get as many people to register as possible, thinking, okay, this is opportunity. This allows you to normalize your life in a certain way, but it is not a permanent solution. It is, as a matter of fact, not a solution. So you had all sorts of expectations. You also had an amorphous population. And so it worries a lot of people, because the thing is, though, that there is always the worry on different sides of the political aisle, if you like, that is the executive sort of exceeding its authority. Now, I take the position, let's discuss a second the legal side of it. There is arguably a problem with using the concept of deferred action. But see, the problem with deferred action is that deferred action is, a lot of people say, well, there's no statutory authority for it, but the truth is that if you go to 212D5, which is the parole authority, and one of the odd things, if you want to laugh, we're talking about the Homeland Act in 2002 created the Department of Homeland Security. Throughout the act, you will see that nobody ever bothered to edit it to distinguish between the Attorney General and the Secretary of Homeland Security. And for obsessives like me, it becomes really irritating, because the question is, okay, is it the Attorney General, or where exactly is this specific delegation from the Attorney General to the Secretary of Homeland Security, or are all the authority, or is every power given to the Attorney General related to the issues delegated to the Department of Homeland Security? And the answer is no one knows, because it's nowhere. It's not clear. So historically, you had, prior to the Tulane situation and prior to the hurricane situation, you had, in the 1960s, you had something called extended voluntary departure. And extended voluntary departure was sort of like, what do you do with a couple 100,000 Cubans who were stuck here, and we have a problem? Now, there's legislation on November 2, 1966, and it kind of resolved the issue. Then, under the first Bush administration, you had the concept of what was called deferred enforced departure. And the answer was, well, what is that? But we came up with an acronym, because immigration people love to come up with an acronym, so it was DED. So everybody who we could possibly get a work permit for was under DED. And so under 8 CFR 274 C14, you have the concept of a work permit being available to people who have deferred action. Deferred action was normally given in one of two scenarios. One is it's given in the area for humanitarian reasons, and it's really disturbing, because in the humanitarian area, we're not being humanitarian enough sometimes, and bring it back to my fear of government and my fear of bureaucracies. It's kind of it's always been implemented in an arbitrary way. He who has a godfather gets baptized. In other words, if you have the right person who's able to walk it through, you would be more likely to get deferred action than not. If a congressperson called, if a senator called, you would, and the more horrifying the illness, the more likely you were to get this. I remember the very kind person from the Texas Service Center calling me about this poor young man who had cancer, and she would always call, make sure that we renew it on time. She was calling me because she was so concerned about him. So it isn't like we must stop demonizing one side or the other, because it really is unproductive. Now, that said, you have the issue of, let's go back to 212D5. 212D5, in terms of the parole authority, it's basically a person who's allowed to be here on their word, parole. The word means on your word, basically. It means word. And so the issue is, why didn't they call it parole? Why didn't we use the same concept of the program that's called Parole in Place? Parole in Place is this program that was created for military families. And so the issue is, well, what jargon would have been the correct one? Because the issue was, we have a problem and we don't resolve it. And so this problem has been fermenting for an extraordinary long time. Go back to 1996, when you had one of the main, I believe this is the one you were referring to, the IRA, where you have a reaction to the 1986 and 1990, and so you have sort of Congress behaving in an odd way, where Senator Simpson was at one point joking, do you understand that I am and on this panel, I am now the most pro-immigration person? And the answer was, he was, because he, in a way, understood immigration. And those who understand the mechanics of immigration are usually ignored in big policy decisions. And so we have a problem, because there used to be a remedy that would have eliminated the complete need for the DREAM Act or for any other such things as DACA, which was called suspension of deportation. So suspension of deportation was this mechanism that if you spent 7 years in the US, no matter in what status, unless you were a crew member or stowaway, that was a different situation, or unless you were paroled into the US, because suspension of exclusion did not exist, suspension of deportation did. So again, the mechanics and the jargon of immigration. But if you had been here 7 years, and if you could show that you're a person of good moral character, if you were a person who would suffer extreme hardship, you would be allowed to remain in the US and get your residency. But Congress eliminates that. Congress says, oh no, that's being granted too generously, so we will have to do away with that. And so the issue becomes, we've known about this problem now for an extraordinarily long time, since the Plyler case was decided, and yet we failed to address it. As a matter of fact, one of the bigger problems with most of the legislation that I've seen proposed is that it doesn't have a prospective sense of what do we do with the next 1 or 2 generations that will be here without status. And so we have a problem. Now, let's bring this to the issue of practical litigation. One of my favorite things is, of course, that people forum shop. And we know this. I mean, like, I know that in law school, we have always... I
told them the same thing. You should forum shop. You should all forum shop.
Yes. This is why probably people don't like us in regular academics. But the idea is that people choose. If you know that you're going to litigate against DAPA, you go to the judges in Brownsville, I believe it was.
That's right.
And you knew that those 2 judges, you know which way it was going to go.
There's only one, actually.
One now?
At the time, there was only one.
Well, only one?
Yeah.
Oh, for some reason in my mind there was always 2.
You had him. There was one guy.
One guy. Okay, so.
It was a senior judge wasn't taking those cases.
Oh, okay. So it was a done deal. So then the issue was, okay, we know which way it's going to go. By the way, on the other side, people go to the Northern District of California, and they know that the Ninth Circuit will go one way or the other. And so you have forum shopping galore. And so the issue is that it's dangerous when the judiciary is being sort of stacked one side or the other, because I think Chief Justice Roberts is correct that they should be referees, understanding that judges, that some, according to one of my friends, There's a certain referee who is blind. I think he has the eyes of an eagle, but it's an amazing thing because it's always interesting when you listen to different perspectives on certain judges. And the answer is we have a problem, because if we're looking at an APA action, and I'm one of those people who very much agreed with Justice Scalia that before you go to the Constitution, you go to the APA, and you get, if you ever have a chance, read this interesting case called Judalang, that it's decided not on constitutional issues, it's not decided on equal protection issues, it's decided on APA issues. But again, lawyers are not thinking in terms of, well, because by the way, lawyers you always have to throw in everything, because if you don't, then someone will say, oh, but you didn't raise this issue, and you don't want to be that lawyer who forgot to include whatever issue. I assure you, when you plead everything, and as long as it meets the requirements of Rule 11, in other words, that it's within the boundaries of the law and the facts, you plead. But the thing is, though, that you don't necessarily, when you get to the point of a solution, you don't have to decide it at a constitutional level. You can decide it at the APA level, or you can, if we go to the sort of the delegation issue, and the issue is, it's an interesting thing, because you have this tension currently where for some things, some people are saying that the courts should give less deference in terms of the challenges to the Chevron ideas. In other words, too much deference given in the area of supposed expertise. And then you have people who are saying, well, yes, we shouldn't be giving deference, but in the end, they give you the same thing. They decide, okay, well, we're not giving deference, but if this is how we're deciding it, in other words, they're giving deference anyway. They're allowing the executive to have too much power. And so it becomes a problem. Now, one of the interesting issues is when two people don't completely disagree on a panel like this, because the issue is, I do believe that there will be, sadly, a negative decision in the Supreme Court. I think it would be, in a way, wrong, but I wouldn't even go down the animus route. I think, and I agree with you that I don't think it would go down that way, but the question is, when a decision is made by an administrative agency, is it based on reasonable action? Reasonable action if there's a legal misinterpretation, because the question is, did they have the authority? In other words, did the Obama administration have the authority to create DACA? Well, DACA is just an extrapolation, and see, this is where we do disagree, that I don't think it's the numbers, because if it's available to one person, it's available to many. And this is where I think that we have to think, and we have to be careful. Because if you do have a program and everyone figures out this program, think of it in terms of tax benefits. If one person figures out the loophole and everybody jumps on board, does this mean that the loophole is illegal? No, it's just that one person figured it out and then everybody else started using it, right? And so in a way, this is the same kind of scenario where you do have deferred action. Now, deferred action on the other side, by the way, I mentioned humanitarian, but one of the things that scares me about deferred action is that we've been granting deferred action to serious criminals, extraordinarily serious criminals for years, some of whom, by the way, make 10% or more based on confidential informant agreements. And these individuals are living here amongst us who, by the way, some of them were deported and were brought back and are here under deferred action. And how is it logical to say that we can give this individual deferred action, but a young person who has, who can't even have not a particularly serious, but a serious misdemeanor, or 3 misdemeanors or a felony, and this includes, by the way, traffic misdemeanors. Like if your tag is expired, I believe it's more than 4 months in Florida, if I'm not wrong, then that's a traffic misdemeanor. And so it's a problem because traffic misdemeanors count against these young people, but yet we'll give deferred action to serious, in some cases, murderers. I happen to know them. And
hopefully not too well.
Oh, God. You'll never be representing lawyers. You don't represent saints when you're practicing, I assure you. Always remember, everyone has a right. Everyone must be defended.
I agree.
Whether they win or not, that's a different story. But this is our mission. Our mission is to make sure that individuals are protected in the courts, because it's a really messy system. So go back a second. And so, given that deferred action it was implemented in bipartisan ways, it was implemented by law enforcement because it was pro-law enforcement. Given that there is enough statutory basis, if you look at 212b5, if you go between 235 and 240, 235 is where you have the section in the INA that allows detention and removal. And so I understand there's the current catchphrase of detain and deport, or detain or catch and release. I understand all the public jargon. That's not what we lawyers worry about. There is enough statutory authority in there to be implemented. Now, like TPS, like temporary protected status, there you have the word temporary and it continues to be renewed. Now, and why? Because we don't solve the problem. Because we stick our heads in the sand and Congress doesn't take the action that it should, and the executive doesn't work always with whoever is in control of whichever house, and we're stuck. And so it becomes a messy situation. Now, I wish I had a very clear answer for you, other than I do believe that there's statutory authority, and if you do go specifically to the parole section, in the parole section, if one of the mechanisms why people are paroled are people, if you're not admitted, if you can't be admitted, we've used parole authority, for example, to bring in people through the freedom flights. We brought in hundreds of thousands of people through the freedom flights from Cuba. We brought in people because we have to move a population, and we are the kind of country that does do this. And so the refugee quota doesn't do it, but we can't leave certain people exposed, so we bring them in under the Attorney General's parole authority. And it's meant to be flexible, but again, we have to de-escalate the tension, and we have to de-escalate the sort of destructiveness, because the problem is that whenever you have the Supreme Court issuing decisions, you begin to have precedent, and then we have to live with it. And so we have to be careful, because I always tell people, yes, it's great, that's a wonderful argument, but we're going to get a lousy decision. And so you need to think about when things are being decided, because 5-4 or 6-3, whatever number you want, it becomes a problem one side or the other, because then you don't know what future executive might be able to do with certain types of authority vested in them. And it's dangerous to have the Supreme Court vesting authority in people.
Great. Moving on for questions.
Yeah, let's take some questions.
All right, so I have one for both of you. I think you would both agree that Congress is should be in the best position to resolve DACA, but it doesn't seem like they will. So, what do you wish to come out of DACA in the end? What do you want to happen? What do you think is the best solution?
That's my friend, the immigration lawyer. I'm the humble constitutional lawyer. Not so humble, maybe. I don't know.
No, believe me, if there's ever humility, it's in the world of immigration. No, it's the answer is that I don't know what the long-term solution is. There are some people who've been able to resolve their statuses in different ways, but the truth is that we have a problem that we need to address, and the answer is, see, you have family-based immigration, you have employment-based immigration that fails to address everybody else in the world. And so there is no mechanism for everybody else. And so, and I harp on this because I know that some people think that it's inappropriate, but I really do believe that we are the city on the hill, and that we are the place to come to for safety. We are the place to come to for hope. And it's not going to stop, because if you go anywhere else, or if you're someone like me who deals with people from places that are hell, because if your child's life is in danger, what would you do to save your child's life? If your loved one's life, not a child, but a loved one, a spouse, a parent, is in danger, what would you do for them? What would you do if, I was talking to this 19-year-old the other day, and I was so impressed with him because, by the way, he has absolutely no legal solution, but my God, what an impressive young man. And by the way, he has no education, but he's been supporting his family since he was a little boy. And all he could tell me was, what can I do? And I said, nothing. You have to survive the best way you can, understanding that there is no legal solution for you right now. And it's a problem because people like this young man are not going to stop, because we are still the place where there is opportunity. The economy goes up and down, markets crash, markets go up. For goodness sake, I mean, it's like, there'll always be a problem. There's always a problem. I mean, think of, it's like Star Trek. What next? What universe are we saving next? But I don't know the answer. I wish that we would return to a mechanism like suspension, where, and one of the interesting things is that one of the arguments, I believe, was that the president gave blanket deferred action. The answer is no. Each application is a separate claim. Each application is a separate consideration. Each application is an act of discretion. And the thing is, though, that one of the things that's extraordinarily important is that most people don't understand that there are only two, well, I'll say two, shalls in the INA, in the Immigration Nationality Act. One is for the creation of a record of removal, and the other one is for what's called withholding of removal. Otherwise, there are no rights. Everything within the INA is discretion. Otherwise, and it's a problem because there is no clean, clear solution. Now, this is a major problem in terms of our constitutional structure, because the question is, when one side or another disagrees with what the other side's doing, then like, people like start fighting, and it's like and like saying, oh, but this and that, and the answer is, that's nice, but like I told the 19-year-old, there's nothing for you right now. Sometimes we lawyers have to tell the clients, bring it back, tone it down. Let's go talk to the other side and see if we can work things out. But it's a sad thing when people who I think are all well-intentioned do not speak to each other to try to resolve problems practically.
All right, another question. Yes.
Quick question. As far as like implicit congressional delegation goes, and I can be really confused when I ask this question. I guess that's why I'm asking it. How does this relate, or how would this relate to Chevron? What does Chevron have to do with any of this? Is it distinguished, in your opinion? Is it more similar?
I'll take this one. Thank you. Chevron was a case from the 80s, and Chevron had a holding. When you have a statute that's ambiguous, and the agency interprets that statute, the courts will defer to that interpretation so long as the interpretation is reasonable. It's a deference doctrine. Here, it's not really a Chevron case, right? The statute issue aren't ambiguous. They're sort of open-ended. And the question is one of whether deference, in a different fashion. Let me explain why. The administration says, we determined that DACA was illegal. And the Ninth Circuit said, no, you're wrong. We think it's legal. Well, sometimes people disagree, right? Does the fact that a court says we think it's legal, does that mean necessarily that the decision of the government's unreasonable? Because the government could have said, we anticipated an injunction and we did this to avoid an adverse ruling. So there is a deference argument, but it's not based on the Chevron doctrine.
It's there are different forms of deference, but in terms of administrative law. But one of the issues is there's always the claim of expertise within the agencies, and of course within immigration, the claim will always be, oh, we are the experts on, and then they throw in the plenary power doctrine, and so we have even more discretion. And the idea is that it's in my mind, there is a mistake in deciding that DACA itself was illegal, because DACA itself is at most a corollary. And as a matter of fact, in a bureaucratic sense, they created a separate sub-regulation C-33 for the people who were receiving DACA, because the subsection under C-14, the idea was that everybody wanted to make sure to be able to keep track. And so when you're doing a search, not like the public, but if the government's doing a search of who has deferred action, you want to see who those people are, because you want to keep track of that population almost much more than you want to keep track of the dreamers. The dreamers are, like, for the most part, my joke was that you're going to have a bunch of accountants and engineers and lawyers, for goodness sake, but it's an interesting thing. I do believe that the problem when Mr. Sessions and others like him and Mr. Miller were fighting this, it was because it was a part of a bigger agenda. And now, if the issue is, well, we just don't feel like it, then that's an interesting statement. Because the question is, okay, you're the Attorney General, okay, you're the President, and you don't want to do it anymore, can you do it? As opposed to saying it's illegal. It's not illegal. You can simply say that you just don't feel like it, because the truth is that, as a matter of fact, Mr. Sessions and Mr. Miller were extensively involved in obstructing anything that could reasonably pass on a bipartisan basis in the Senate. And so once you're running the immigration system, it becomes more of a, okay, we did it out of sheer political will, not because of the law. Now, here we are litigating.
I think actually we're out of time. I'm so sorry.
All right,
But if you want to come up, we can get you. Actually, no. Okay, go ahead. Ask your question. Go ahead.
Oh,
And we have like 2 minutes left, but let me.
Yeah, you take it.
Yeah, I'll take it. Yeah.
Okay, so if the program disappears, okay, if just Congress won't do anything, that's it, gone. Will those Americans, because they are Americans without a document that says it, I mean, they feel like Americans, so will the government just take them out?
Not likely. I think what will happen is they just will remain deprioritized, but they'll lose their work authorization, which is the big issue, right? Let me actually close on this point. If all DACA said is we will deprioritize the dreamers, I would not be making the argument I'm making. My argument is primarily about the lawful presence in the work authorization, not the deportation. I think you could prioritize within the statute, but you can't grant this much work authorization. And I'll have to leave it there. But thank you for the question.
all right. Thank you so much, Mr. Blackman, Mr. Gomez.
I got flights to catch.
No, 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 no.
Thank you.
Thank you so